Welcome to another episode of What Does the Law Say? Before we move on, please like, share, subscribe, and drop your comments and questions below. Thank you. I would like to answer a question sent by a viewer as regards the last episode. If you remember, the last episode was as regards police search. And if you have not seen the video, just go back, watch it, learn something new, and also send me your questions. So the question was, can we take police officers to court if we believe they have violated our rights? And the answer to that question is yes. If the police officer has violated your rights, you can file a complaint against that police officer and the police force, or file a fundamental rights action against the officer and the police force. And you can do this through your lawyer. Thank you very much for the question. I hope I've been of great help to you as regards providing the answer. Our discussion for today is centered on the rights and obligations of a tenant in a landlord and tenant relationship or a tenancy agreement. So if you've noticed, if you've ever been a tenant, at some point, people over time get familiar with their landlords, maybe either the landlord or the landlady or the children, and sometimes neglect or out of ignorance do not even know they have rights as a tenant. And so today's discussion would basically answer questions such as, do I have any rights as a tenant? What rights are available to me as a tenant? And what exactly are my obligations as a tenant in a landlord and tenant relationship? In today's episode, we will examine provisions of the Tenancy Law of Lagos State 2011, basically. And this is because most other states are patterned in that way or patterned in that light. According to the Tenancy Law of Lagos State 2011, tenancy agreement means an agreement, whether written or oral, expressed or implied, between a landlord and a tenant regarding possession of premises and use of common areas, and includes leases and subleases. So under the Tenancy Law of Lagos State 2011, a tenancy agreement is that relationship between a landlord and a tenant, over a premises or over a building. So just as the law provided, just as the Tenancy Law of Lagos State 2011 provides, your tenancy agreements can be oral, can be implied, can be expressed, or can be written. Usually a tenancy agreement is below 3 years, and if it is a lease, it's usually above 3 years. The Tenancy Law of Lagos State applies to areas within Lagos State. However, there are instances where the law doesn't apply in Lagos State. Areas such as Ikeja GRA, Ikoyi, VI, and Apapa, this law doesn't apply. So what are the rights available to me as a tenant in a landlord and tenant relationship? The first right is that you have the right to a written agreement. Section 3 of the Tenancy Law of Lagos State 2011 provides that a tenancy agreement can either be oral, it can be written, it can be expressed, it can be implied, it can be partly written and partly oral, or for a fixed period. However, in this age and day, I don't think it is safe for you to have an oral agreement for a tenancy agreement or for a landlord and tenant relationship. It is your right to have a written agreement. The advantage of having a written agreement is that it makes the terms of that agreement ascertainable. You can be sure that the premises where you are is number 2 Kofowojewo Street. You are sure that this is your room. You are sure that this is your bathroom. It makes everything ascertainable. There are no mistakes as to the agreement, unlike an oral agreement or a partly oral and a partly written agreement. You might meet agents or landlords that just want to hurriedly make you just say, don't worry, it's your room, you've paid, we know that it's yours. No. Most times, you have a lawyer draft a tenancy agreement on behalf of tenants. However, if you do not have a lawyer help you draft your agreement at that time, ensure that your agreement is written. Ensure that whatever you and the landlord have discussed, whatever agreement you've made that you've agreed to, you write it down and you have a copy of that written agreement. The advantage of this is so that you can ascertain the terms of the agreement. You don't want to assume that he said the toilet downstairs is your own, or the parking garage is your own, and that's not what he said. It is your right for you to have a written agreement. Don't just have an oral agreement. Don't hurriedly also just sign that agreement. You want to be sure that a legal practitioner proofreads and reviews this agreement for you. So the Tenancy Law of Lagos State 2011 also provides that the tenant has the right to freedom of unreasonable disturbance. That means your landlord shouldn't just come and be disturbing you, be barging your house or banging your door, or reasonably disturbing you. If there's any reason why they need to talk to you or speak to you, that's different. But you have that freedom. You have that right. You have the right to peaceable enjoyment of your premises, of where you've paid for, of where you know that belongs to you. You have that right to peacefully enjoy it. So thirdly, you have the right to privacy. You have the right to your apartment, your building, your room, your premises, whatever you want to do there is your business. It's as long as you've fulfilled the terms of the agreement, then you have the right to privacy. You can enjoy that place you've paid for, and enjoy your private life. You are not meant to be disturbed or be watched. What are you doing? What is that tenant doing? What is he saying? What does he watch? Where does he go to? No, you have a right to privacy. So you also have a right to exclusive possession of premises, which means that you have exclusive possession, absolute right to possess that room, that building, that apartment, that premises that you've paid for already. No other person, whether the landlord or any person, should be allowed into your premises except if you've granted consent, because you have the right to exclusive possession of that premises. If you've not granted consent, their entrance into your premises will be seen as trespass. You also have a right to notice to quit. No landlord can evict his tenant without issuing a notice to quit, except if in the tenancy agreement it has been stated or it has been agreed upon that whenever the agreement is to be terminated, there is no need to issue notice to quit. That means it's seen that you waived your right to notice to quit. Section 13 of the Tenancy Law of Lagos State 2011 provides that where there is no stipulation as to the notice to be given by either party to determine the tenancy, the following shall apply: a week's notice for a tenant at will, 1 month's notice for a monthly tenant, 3 months' notice for a quarterly tenant, 3 months' notice for a half-yearly tenant, and 6 months' notice for a yearly tenant. The notice to quit must be calculated properly. If it is not calculated properly, it won't be valid. So there's a way which the notice to quit is calculated. For a yearly tenant, it will start counting from the eve of the anniversary, and from a monthly tenant, it will start counting from the anniversary of the tenancy. A notice to quit would not be valid if that tenancy is still subsisting. It is your right to notice to quit. If the landlord or landlady does not issue a notice to quit, depending on your agreement, then they have no right to evict you. Flowing from that, the other rights available to you as a tenant is the right to 7 days notice of owner's intention to recover possession. A 7 days notice of owner's intention to recover possession can only be served on the tenant after the expiration of a notice to quit. So where a 7 days notice is served on a tenant during the lifespan of a notice to quit, that 7 days notice would be regarded as invalid. So the 7 days notice of owner's intention to recover possession comes after the expiration of the notice to quit. So you cannot serve the 7 days notice of owner's intention to recover possession during the lifespan of a notice to quit. So it's after it. If the tenant does not vacate the premises during the lifespan of the notice to quit and the tenant stays up until the expiration of the notice to quit, the landlord can serve the tenant through his lawyer a 7 days notice of an owner's intention to recover possession. That means you are saying that after 7 days, if the tenant has not left the premises, if the tenant has not vacated the premises, then you bring an action for eviction against the tenant. If your landlord or landlady does not issue a 7 days notice of owner's intention to recover possession, then they cannot bring an action for eviction against you. So the only way or the only reason why an action for eviction can be brought against you is that notice to quit has been served and a 7 days notice of owner's intention to recover possession also has been served. So if 7 days notice is not served on the tenant, an action can't be brought against such tenant for eviction. However, if it is terminating the agreement unlawfully or in the middle of a subsisting tenancy, then you might have to consult your legal practitioner so that you can bring an action against the landlord. You have the right to the use of common areas for reasonable and lawful purposes. So as long as you're a tenant in a landlord and tenant relationship, the Tenancy Law of Lagos State provides for you that you have that right to the use of common areas for reasonable and lawful purposes. So there's no, we are the ones that came here in 2002. We are the ones that are using this tap. We are the ones that came here since 2016. This is our own parking space. No, you have every right as a tenant to the use of common areas for reasonable and lawful purposes. What are the obligations of a tenant? We've explained the rights of a tenant. Now, let's go into the obligations. That means the duties of a tenant in a landlord and tenant relationship. You are meant to pay your rent. Obviously, I think that is not rocket science. You are supposed to pay your rent. You don't have to be begged or be threatened, you know. That is your obligation. That is your duty. Don't now say that I have the right to notice to quit. So if I'm a yearly tenant and because I know I have the right to notice to quit, I'm going to wait till that 6 months expires. Do not say that because you know that you have a right to notice to quit. You know that you have that 6 months notice. You will now decide not to pay your rent. No, it's your duty. It's your obligation. You are meant to pay your rent and pay your rent on time. Pay your rent at the time stipulated. The Tenancy Law of Lagos State provides for these obligations, provides for these duties. That as a tenant, you are supposed to pay your rent at the time stipulated. Also, a duty of a tenant is to keep the premises in good condition. Ensure that you are not causing any damage as a tenant. It is the obligation of the tenant to permit the landlord and his agents to come into the premises within reasonable hours during the daytime to effect any repair or any maintenance or anything that needs to be done on the premises. But you must note, it must be with consent. It must be that you've granted the landlord or his agent's consent. If you've not granted them consent, then they cannot just come into your premises. It is your obligation as a tenant not to make any alterations or additions to the premises without the consent of the landlord. Don't alter or don't add anything that the landlord has not consented to. If he should give his consent, then you can make any alterations to the premises or any additions. You will not now make any alteration and addition that he did not consent to, then later now come and ask for compensation that you did this, you repaired this, you repaired that. It is your duty as a tenant not to make any alterations, not to make any additions without the written consent of the landlord. It is also the obligation and the duty of a tenant not to assign or sublet any part of the premises without the written consent of the landlord. So if your tenancy agreement says that you have this apartment, don't now sublet your own apartment without the consent of your landlord. If at all you want to sublet that apartment, let your landlord consent to it. If it should consent to it, then you can sublet or you can assign it to another person. But it is your obligation to fulfill, to make sure that you do not assign or sublet any area of the premises without the consent of your landlord. It is your duty as a tenant to notify the landlord of any substantial or structural damage to any part of the premises as soon as practicable. Don't have the mentality of, it's not my business, it is not my premise, it's not my building, I'm not the owner of the house, whatever happens. No, as long as you are living there, it is your duty, it is your obligation to notify the landlord of any repairs that need to be done or any damage or anything that needs to be done at all in the building. My advice for you, as a tenant with all these rights and obligations, you want to make sure that you are in a tenancy agreement that favors you. So firstly, don't just sign any agreements. No matter how hurriedly the agent comes at you, no matter how good the deal might sound, no matter what your landlord says to you, ensure that if you are getting into a tenancy agreement without a legal practitioner, you review the agreement very well. If you do not understand the terms of the agreement, it is best that you consult a lawyer. In conclusion, to avoid stories that touch when it comes to tenancy agreements, just allow your lawyer so that the terms of the agreement favors you in every way. However, if you are in a landlord and tenant relationship and some rights may have been denied already because you didn't involve your lawyer and you were not aware of it, it's not too late for you to enjoy those rights. Consult a legal practitioner and know how you can seek remedy in that tenancy agreement. I hope you're able to learn something today. Thank you for listening. Please like, share, subscribe. Drop your questions and your comments below. Bye.